Hello, everyone, and welcome to the fourth lecture of the global seminar series on citizenship stripping hosted by the Institute on Statelessness and Inclusion, or ISI for short. My name is Gaia Vlieks, and I'm Research and Education Officer with the Institute, and I also coordinate the Year of Action Against Citizenship Stripping that has been initiated by ISI and its partners. The online global seminar series on citizenship stripping are part of this ongoing year of action, and the initiative was started because in recent years, citizenship is being threatened because of the growth of the security state, increasing populism, xenophobia, and racism. We see states instrumentalize nationality and treat it as a privilege that can be taken away, or as a punishment, which results in members of minority communities, human rights defenders, dissidents, and suspected terrorists being targeted with nationality deprivation measures. The global seminar series on citizenship stripping aimed to unpack and understand the background of and problems around citizenship stripping, presenting a different perspective by key experts on the issue in each seminar. All seminars in the global seminar series on citizenship stripping take place on a Monday at this time. In previous lectures, Professor Matthew Gibney from the University of Oxford considered banishment and the prehistory of denationalization, and the Magna Weston Queen's Counsel looked at the right to a fair trial and effective remedy in relation to nationality deprivation in the UK. Furthermore, during our last lecture, Jawad Farouz considered the issue in the Bahrain context and shared his personal experiences. These lectures are all now available on our website in case you missed them. And there are also lecture and debate kits available to accompany each of these lectures so that you, your students, or others can learn more about these issues and discuss. The next lecture, and for now last lecture of the Global Seminar Series, will take place on June 14. During this lecture, Dr. Christoph Paulussen and Professor Martin Scheinin will provide a human rights and security perspective on citizenship stripping. More information and registration is available on our website. Today, we continue our global seminar series with a lecture focusing on citizenship stripping, statelessness, and international criminal law. I'm very honored that we are joined for this lecture today by CÓMAN Kenny. CÓMAN Kenny is an Irish barrister currently working as a legal officer at the United Nations. He's a graduate of the National University of Ireland, Galway, Leiden University, and the Honourable Society of King's Inns. Prior to his current role, he served as a prosecutor at the Special Court for Sierra Leone, the International Criminal Court, and the Extraordinary Chambers of the Courts of Cambodia. He's also worked as a defense lawyer at the International Criminal Tribunal for the former Yugoslavia. CÓMAN has published widely on issues of international criminal law and public international law. He's, for instance, contributed an international criminal prosecutor's perspective to ISI World Stateless Report on deprivation of nationality, and recently published an article on mass arbitrary deprivation of nationality resulting in statelessness as an international crime in the International Criminal Law Review. Mr. Kenny, thank you so much for joining us today and for providing your perspective on the issue of citizenship stripping. I'm very excited to learn more, and I'm sure the participants that have joined for this seminar are too. Before I hand over to you, allow me to make a couple of announcements for the audience. So this seminar lasts 1 hour, and after the lecture, there will be ample time for questions and discussion. All participants can use the Q&A function in Zoom to ask any questions you may have or comments you would like to share. Mr. Kenny, thank you again, and the floor is yours.
Thank you very much, Gaia. And thank you to the ISI for the invitation to speak, as well as to everyone who has taken the time to tune in. Now, as the title of this lecture indicates, the perspective from which I want to discuss the issue of citizenship stripping is through the lens of international criminal law. And given the myriad causes of statelessness, this is not a proposal that every instance of citizenship stripping could engage criminal responsibility. States, of course, have a measure of discretion to deny or deprive citizenship, and human rights violations only fall within the ambit of international criminal law when strict requirements are met. International criminal law, moreover, is not a panacea for this extremely complicated issue. That said, my focus is on one particular aspect of citizenship stripping, namely situations where a minority group is arbitrarily deprived of its nationality, resulting in the statelessness of its members. which I will refer to as denationalization-induced statelessness in this lecture. Now, this type of state action has been used as a tool to target groups in order to marginalize and oppress. The human rights implications for those affected are profound, and such targeted discrimination creates a permissive atmosphere of dehumanization that can threaten a group's existence and has in the past been the precursor to mass atrocity crimes. This is not an attempt to expand the remit of international criminal law, but to apply the existing law to the facts where warranted. The absence of any discussion of accountability in situations of denationalization-induced statelessness results in a uniquely aberrant situation of state-sanctioned discriminatory mistreatment that causes serious violations of human rights, but does not carry even the threat of the individuals most responsible being held accountable. In this lecture, I want to build the argument for international criminalization through several steps. First, to look at the legal status of deprivation of nationality, specifically to show that arbitrary deprivation of nationality resulting in statelessness is prohibited under general international law, and that there is thereby a basis for criminalization. Second, reviewing the types of harm suffered due to the condition of statelessness, to demonstrate that the gravity of such harm warrants the invocation of international criminal law. Third, to highlight the link between denationalization-induced statelessness and the commission of international crimes, which is not a prerequisite for criminalization, but reinforces the argument that it is necessary. Fourth, to review the historical precedent for criminalization, to show that the current proposal has an existing legal foundation in international criminal law. And lastly, to look at some of the international crimes that denationalization-induced statelessness could constitute. So turning first to the applicable general international law. Though states have a discretionary power to decide who its nationals are, this is not absolute and it must comply with human rights obligations. The right of every individual not to be arbitrarily deprived of nationality, particularly on the basis of race, national origin, ethnicity, or religion, is guaranteed under international law. This has been something of an evolution over time. Nationality has developed from an aspect of pure sovereign authority to a fundamental human right. The shift occurred predominantly in the latter half of the 20th century, specifically in response to the millions of displaced persons created by World War II. A key turning point was Article 15 of the 1948 Universal Declaration of Human Rights, which set down not only that everyone has the right to a nationality, but that no one should be arbitrarily deprived of their nationality. And this was, of course, followed by two specialized treaties on statelessness. The 1954 Convention on the Status of Stateless Persons, which was limited to defining stateless persons and trying to secure them the widest possible exercise of fundamental rights. And the 1961 Convention on the Reduction of Statelessness, which for the first time imposed positive obligations on states parties to grant nationality in situations where the person would otherwise be stateless. Now, significantly, the 1961 Convention allows deprivation of nationality resulting in statelessness under limited circumstances. However, it expressly forbids states parties from depriving any person or group of their nationality on racial, ethnic, religious, or political grounds. Now, preventing members of a group from obtaining or retaining their nationality on discriminatory grounds is not only an arbitrary deprivation of nationality, but a breach of the well-established international law principle of non-discrimination. This is seen, for example, in Article 5 of the International Convention on the Elimination of All Forms of Racial Discrimination, which requires states parties to guarantee, without distinction as to race, national origin, or ethnicity, the right of nationality. These and other legal instruments, both regionally and internationally, and pronouncements, demonstrate that arbitrary deprivation of nationality resulting in statelessness is impermissible under general international law, thus providing a foundational legal basis for international criminalization. So in terms of the human consequences of the condition of statelessness, because citizenship is a practical prerequisite for accessing judicial and political processes and for obtaining economic, social, and cultural rights, being stateless often robs the individual of the means by which to access their fundamental rights and freedoms. The daily existence of those affected by statelessness involves interwoven discrimination affecting all facets of life. Stateless persons can face ongoing violations of the rights to liberty, to health, education, freedom of movement, family life, work, housing, and access to justice, amongst others. The impact of statelessness is felt particularly severely by women and children, who are at a higher risk of kidnapping, of sexual exploitation, human trafficking, and forced recruitment into armed forces. Now, on top of the harm suffered by the individual, the effects of statelessness on minority groups are considerable. Once deprived of citizenship, groups are often denied protection of their minority rights. And examples include the right to protection of the group's cultural identity, such as recognition and use of minority languages, or the freedom to practice minority religions. Moreover, the impact of statelessness on issues such as ownership rights, employment, or access to services means that states can effectively deprive minorities of access to wealth and resources. And this often results in impoverished, uneducated, and disempowered groups that are vulnerable to further discrimination. Not only does this situation affect the immediate term, but where perpetuated, the precarious position and living conditions of those victimized are greatly exacerbated by intergenerational statelessness. And for such reasons, the UN Secretary General has noted that statelessness has a determinative impact on the protection of a minority's survival and existence within a territory. So given the extent of the various deprivations that individuals and the groups to which they belong may suffer, the gravity of the harm experienced by those targeted by denationalization-induced statelessness clearly calls for international legal scrutiny. And the need for such an examination is heightened by how denationalization-induced statelessness has been used by states as a policy to discriminate against minorities. History shows us that states have taken deliberate action to exclude populations from integrating into their citizenries through distinctions in the application of nationality laws. Denationalization-induced statelessness thus offers a means of targeting a group and depriving them of their rights under the veil of the sovereign act of legislating for citizenship. Groups are typically targeted because they are not considered to belong to the society due to their minority status, because they are viewed as extensions of other powers, such as where there is a neighboring state with a similar ethnic composition, or because their ancestors may have migrated to the territory in the recent past. States may also denationalize minority groups for political advantage. Exclusion of part of a population can create social and political tensions that provide an opportunity to exploit division by those in power. Deliberately induced exclusion, when accompanied by an exacerbation of divisions between groups in society, provides fertile grounds for intolerance. This creates a permissive atmosphere of mistreatment of the targeted group, which, as events have shown, has allowed and even facilitated the perpetration of serious crimes. The situation of the Jewish population in Germany and German-occupied territories during World War II demonstrates that arbitrary deprivation of nationality can be the precursor to the commission of atrocities against those isolated and dehumanized by the condition of statelessness. Additionally, it provides us with a historical precedent for criminalizing denationalization-induced statelessness. Now, the International Military Tribunal, which is also referred to as the Nuremberg Tribunal, put 24 major political and military leaders of Nazi Germany on trial. Its 1946 judgment described how the Reich Citizenship Law, which was one of the infamous Nuremberg laws of September 1935 and deprived Jews of German citizenship, resulted in the Jewish population being rendered powerless and their influence on the affairs of Germany being extinguished. The Nuremberg Tribunal heard evidence that the deprivation of citizenship of the Jews was an underlying element of the crimes that were subsequently committed against them. To give some brief examples, a telegram from the German ambassador in France to Nazi authorities in October 1940 proposed the collective deprivation of nationality of Jewish Austrians and Jewish Germans in France as the first step towards solving what was described as the Jewish problem. And a March 1942 memorandum entitled Deportation from France of 5,000 Jews stated that Jews of French nationality must be deprived of their nationality before being deported, or at the latest on the day of the deportation itself. Hannah Arendt would later write that the Jews had to lose their nationality before they could be exterminated, because in her words, one could do as one pleased with the stateless. Notably, the lawyer for Hermann Göring, who was the highest-ranking Nazi official on trial, claimed that the passage of racial purity laws and decrees to exclude Jews were domestic matters dealing with the regulation of the legal status of German subjects. He argued that international legal opinion recognized that the German Reich was a sovereign state and was free to settle such a matter. He further claimed, and I quote, "Even if these encroachments were harsh and the limitations of citizenship rights extremely severe, they nevertheless in no way represent an offense against humanity." Ultimately, however, the Nuremberg Tribunal dismissed such arguments and held that discriminatory laws restricting rights of citizenship amounted to the crime against humanity of persecution. Among those convicted was Wilhelm Frick, who had been the Reich's interior minister. The tribunal noted that Frick had drafted, signed, and administered laws, including those depriving Jews of the rights of citizenship. The tribunal described these as crimes camouflaged in the form of legislation that were designed to eliminate Jews from German life and that had, and again I quote, paved the way for the final solution. This and other trials held after World War II are part of the foundations of what we consider to be modern international criminal law. And as such, these cases represent highly relevant precedent for individual punishment of those responsible for denationalization-induced statelessness. So having touched upon the foundational legal basis for criminalizing denationalization-induced statelessness, the need for criminalization due to the seriousness of the harm suffered and the link to the commission of atrocities, as well as outlining the historical legal support for criminalization, I now want to come to the substantive international crimes that could be applicable to situations of denationalization-induced statelessness. At this point, I will focus on crimes against humanity and genocide, using the statute of the International Criminal Court as a reference. So at the outset of any discussion of crimes against humanity, we must first look at what are called the chapeau or contextual elements. These must be met before an assessment can be made of whether conduct constitutes one of the crimes that are characterized as crimes against humanity. And when I speak about conduct or impugned acts, I am referring to the implementation or perpetuation of denationalization-induced statelessness. According to the jurisprudence of the ICC, the contextual elements of crimes against humanity require that the impugned act is committed as part of a widespread or systematic attack against a civilian population, pursuant to a state or organizational policy, and is perpetrated with knowledge that the act is part of the attack. Assessing these requirements in terms of denationalization-induced statelessness, it is important to note that an attack for the purposes of crimes against humanity does not have to be a military attack or involve violence. It could therefore encapsulate the implementation or continuation of discriminatory legislation targeting a minority group. That the attack must be widespread or systematic is meant to exclude isolated events. The term widespread signifies a large scale and a multiplicity of victims. The term systematic relates to the organized nature of the impugned acts and the improbability of their random occurrence. Now, given that denationalization-induced statelessness, as discussed here, involves state machinery to target and make stateless part of a population, it is possible that such action could meet both the widespread and systematic criteria, depending on the circumstances. Additionally, such state action, or indeed inaction, as in the situation where a government or regime perpetuates a discriminatory deprivation of nationality, fits within the concept of a policy for the purposes of crimes against humanity, which requires that an attack was planned, directed, or organized. Likewise, because it is state-sanctioned denial of nationality, the knowledge requirement that connects the perpetrator's acts, for example, the head of a government or regime implementing such legislation, and the overall attack itself would likely be met in practice. Having addressed the contextual elements, the substantive crimes against humanity I would like to briefly discuss are apartheid, persecution, and other inhumane acts. The ICC's statute defines apartheid as encompassing inhumane acts that are committed in the context of an institutionalized regime of systematic oppression by one racial group over any other racial group and committed with the intention of maintaining that regime. And because inhumane acts within that definition are not defined in the ICC statute, we may look to the Apartheid Convention of 1973 for interpretative guidance. That convention lists 9 basic rights and freedoms, which if denied, may amount to the crime of apartheid. And this includes the right to a nationality. Apartheid is, of course, synonymous with the racist regime that held power for decades in South Africa. In 1984, John Dugard described how denationalization of Black South Africans was used in pursuance of apartheid. This, he argued, occurred primarily through the Bantu Homeland Citizenship Act, which decreed that every Black person of South African nationality became a citizen of one of the 10 ethnic homelands then part of South Africa. These ethnic units were then to be granted independence, and the citizens of each unit would lose their South African nationality. Thereafter, when South Africa discriminated against the new aliens by refusing them full civil and political rights, it would do so under the veil of the law, as it was no longer discriminating against its own nationals. Through this legal maneuver, Black South Africans deported to their national states were unable to participate in South African society. And the UN General Assembly described this policy at the time as designed to deprive the African majority of citizenship and to further dispossess it of its fundamental rights, labeling it as an international crime. It is the cumulative effect of violations of international human rights law, where operating to control, dominate, and suppress those targeted, that amounts to a form of systematic domination within the meaning of the crime of apartheid. And going back to the Apartheid Convention, the deprivation of the rights to work, education, to leave and to return to a country, as well as to freedom of movement and residence, are considered acts of apartheid. The violation of these rights, as mentioned earlier, often result from the condition of statelessness. And denationalization-induced statelessness effectively institutionalizes discrimination and fundamental human rights violations to the cost of the targeted group. It could therefore amount to the crime of apartheid. Moving to the crime of persecution, which prohibits severe deprivation of the fundamental rights of an identifiable group on discriminatory grounds. While the content of the term fundamental rights is not defined in the relevant provision of the ICC statute, the rights at issue must be such that their deprivation are contrary to international law. As discussed at the outset, the right not to be deprived of nationality on discriminatory grounds is a fundamental right, and its violation is considered contrary to international law. Importantly, acts of persecution do not have to themselves amount to a crime. Thus, discriminatory acts and policies of a state that may be authorized by its legal regime or perpetrated as a result of legislation are covered by the crime of persecution, as seen in the Nuremberg example discussed earlier. The group that is subject to discrimination may be identifiable by virtue of objective criteria or the subjective perception of the perpetrator, who must have targeted persons because of the identity of the group to which they belong. So this would include targeting on political, racial, ethnic, gender, cultural, religious, or other grounds that are universally recognized as impermissible. A decision to deprive a group of its nationality, resulting in the statelessness of its members, or perpetuating such deprivation, is an inherently discriminatory act that results in gross human rights violations to those impacted and could therefore be characterized as the crime of persecution. Lastly, the crime of other inhumane acts covers conduct which intentionally causes great suffering or serious injury to mental or physical health. Other inhumane acts has been part of international criminal law since post-World War II cases and was designed as a residual crime to ensure that conduct that would not otherwise be classified as one of the listed crimes against humanity would not go unpunished. A pretrial chamber of the ICC has noted that this crime must be interpreted conservatively so as not to expand uncritically the scope of crimes against humanity. However, the sole determinant of whether conduct could be criminalized as an other inhumane act is whether it causes mental or physical pain which reaches the threshold of harm required. International practice has qualified a wide range of conduct as other inhumane acts, including enforced prostitution, deplorable conditions of detention for prisoners, severely injuring peaceful protesters and threatening them with execution, and sniping at civilians. As already laid out, the extent to which statelessness can pervasively impact on almost all facets of a person's life, as well as the anguish and uncertainty of effectively being excluded from society, sometimes for generations, can occasion severe mental and physical harm, and therefore could potentially be qualified as the crime of an other inhumane act. Turning briefly to the question of whether denationalization induced statelessness could amount to an act of genocide. The kernel element of the crime of genocide is the specific intent requirement, meaning that a genocidal act must be carried out with the intent to destroy, in whole or in part, a specific national, ethnic, racial, or religious group. The ICC statute contains 5 enumerated genocidal acts. Denationalization-induced statelessness could, depending on the circumstances, be characterized as 2 of those, namely, causing serious bodily or mental harm to the members of the group, or inflicting on the group conditions of life calculated to bring about its physical destruction. The ICC's elements of crimes notes that acts causing serious bodily or mental harm may include inhuman or degrading treatment. Now, in terms of the required scale of the harm suffered, jurisprudence from ad hoc international criminal tribunals indicates that it need not be permanent and irremediable, but must result in a grave and long-term disadvantage to a person's ability to lead a normal and constructive life. The various ramifications of statelessness already outlined lead to extreme vulnerability and debilitating effects throughout the course of a lifetime that could be characterized as causing serious mental or bodily harm to members of the group affected. Regarding the infliction on the group of conditions of life calculated to bring about its physical destruction, which is also sometimes referred to as the imposition of measures of slow death. The ICC's elements of crimes specify that this may include deliberate deprivation of resources that are indispensable for survival, such as food or medical services, or systematic expulsion from homes. It is not required that the conditions lead directly to death, so long as they were calculated to do so. And again, the myriad deprivations inherent in being made stateless, such as restrictions on access to health facilities, livelihood, and segregation from other communities, often expose those affected to destitution, long-term health risks, expulsion, and preventable deaths. The infliction of such circumstances as a matter of policy could therefore, depending on the purpose of creating or maintaining the group's condition of statelessness, be considered as imposing conditions of life on the group calculated to physically destroy it. The required intent to destroy a group in whole or in part means that a substantial part of the group is targeted for destruction, and there must be a concrete threat to its existence. Viewed through the lens of denationalization-induced statelessness, where this is employed as a discriminatory tool, it demonstrates an intent to target a particular group as a group, and has the potential, for the reasons already discussed, to threaten the continued existence of that group, and thereby potentially amounting to an act of genocide. So to wrap up, mass arbitrary deprivation of nationality resulting in statelessness occasions a multitude of human rights deprivations, crippling the prospects of individuals and resulting in the economic, social, and cultural stagnation of entire communities. It creates an ongoing situation where, in the eyes of a law, that group is undeserving of the most basic rights and protections needed to function with dignity in society. Despite the remarkable impact caused, the perception of regulation of citizenship as a domestic matter shields state officials who would seek to use the law as a pretext to target minorities. Looking ahead, as Kaya mentioned at the beginning of this lecture, the potential that minority groups continue to be targeted in this way should be of heightened concern, given the rise of ethno-nationalist populism and leaders gaining power with the aid of xenophobic and nativist rhetoric. As both history and more recent events have shown, denationalization-induced statelessness is a blueprint through which the marginalization and ostracization of a group is achieved, and ultimately destruction of the group can be pursued. This should be a matter of concern for the international community as a whole, and those responsible for visiting such devastation upon vulnerable groups should be held individually criminally accountable. And on that note, I will thank you for your time and for your attention.
Thank you so much, CÓMAN. Thank you so much for this very interesting lecture, and thank you also so much for using different, very powerful examples to illustrate your different points. So while you were speaking, questions have already come in, and allow me to immediately get started on those. So at the beginning of your lecture, you referred to the fact that international law, international human rights law, as well as the concept of nationality have developed in the sense that first it was seen as more of a sovereign concept, a sovereign authority, and now it's considered more of a fundamental right under international law. And you did mention certain points in history that were important to that end, such as the proclamation of the Universal Declaration of Human Rights and the right to nationality that's contained in there. Do you think that there was is there a specific event that you can pinpoint in terms of the development of the concept of nationality and the right to nationality? Or do you think that it was more of a development slowly over time?
I think it was, sorry for the feedback. I think it was a development over the course of most of the 20th century. You can go back to decisions of the Permanent Court of International Justice in the early 20th century, and then the steady kind of stream of legal instruments and pronouncements that developed throughout the course of the century. As I mentioned, a lot of it was precipitated by the situation of World War II and what to do with all these countless people who were displaced. And so we then get to a stage, I think, by the latter end of the 20th century, where basically all of the regional instruments, the European Convention on Nationality, the Inter-American Convention on Human Rights, the Asian Declaration, and the Arab Charter on Human Rights, they all contain these this recognition of the fundamental status of the right to nationality and the right not to be arbitrarily deprived thereof. So again, I think there's a fine argument to be made as to whether it amounts to something like customary international law, which wasn't really necessary for the point of this lecture. But I think there's probably good arguments to be made on both sides as to whether it is custom. But I think it's certainly there's a clear basis right across the spectrum of the instruments and the decisions in the 20th century to show how it has become something that is, again, while within the discretion of a state, is not entirely without the possibility for review internationally.
Yeah, thanks so much for that answer. And maybe connecting to a bit of the writing that has been done around citizenship stripping in international law. So you see that some lip service is paid to the dark history, basically, of denationalization in contemporary writing and debate on the use of citizenship stripping. But the clear link that is made by your lecture to crimes against humanity doesn't really feature. Why do you think that that's the case? And why is the language of the Nuremberg trials about denationalization as crimes camouflaged as legislation not more widely known or understood? And if I can add to that, what more could be done to promote acknowledgement of this dimension of the issue?
It's a really good question. I think there's probably a couple of reasons for it. I think whenever you are in the realm of a sovereign act, such as deciding who is your national, as we all know, states are quite jealous in how they guard their sovereign authorities and their sovereign power. So I think there is probably a reluctance to view something that is seen as so intricately attached to the sovereign authority, to view that as potentially reviewable on the international criminal level. I think we see pushback from states on anything that they consider to be a potential encroachment on their sovereign powers. I think that's also the fact and statelessness as an issue tends to be a little bit not necessarily invisible, but certainly maybe not given the full attention that it really deserves. And I think maybe the extent to which people who are stateless suffer and the gamut of the types of deprivations that they face is not always fully understood. So I think there's that aspect to it. And in terms of the Nuremberg Tribunal, I'm not really sure why that hasn't been more visible in terms of that particular aspect to it. I guess it's such a rich theme for modern international criminal law to review those judgments and to go through and argue about what was meant, what was decided, what its value is and what its precedential value is to modern international criminal law, that sometimes things get a little bit overlooked. And I think that's the case with the stripping of the citizenship of the Jewish population as persecution.
Thanks so much. That's yeah. I mean, it's a difficult question to answer, but that really helps. So a couple of questions have also come in around how feasible, how realistic it is in the contemporary context to consider prosecution for the crime of denationalization, basically. How realistic do you view this if you consider also the complexity of modern bureaucracies?
Well, I guess it's like any development in international criminal law. There is a point at which it is maybe not seen as being realistic or not being part of the canon of international criminal law, and it takes a push from either a prosecutorial authority or a judicial authority to make those things happen. And we've seen that with, I think, the development of sexual and gender-based violence related crimes and crimes against children, and how there's been a greater emphasis and a greater understanding of those crimes and a greater focus on those in judicial and accountability settings. And there was a time, of course, going back to the Nuremberg example, where you didn't even have rape being prosecuted as a crime. So we've obviously come a long way, and it does take incremental steps sometimes to get things recognized as potentially the subject of criminalization. In terms of being realistic, I mean, again, where you either have implementation or perpetuation of a state policy, it's a case of, at least in my opinion, looking at those who have sufficient de facto influence on either the making of policy or the ability to continue to pursue a policy in a state environment. So yes, there's lots of level of bureaucracy in any administration, be it a liberal or an illiberal one. But again, if you look at something like the crime of aggression, for example, which is another crime that has developed relatively recently after some teething problems and still has a long way to go, let's face it. But that's considered to be a leadership crime because of the nature of the state's decision to go to war or to attack another state. And I think that denationalization induced statelessness, as I discussed, would be something similar to that, in terms of you would be looking at those who actually have a clear and identifiable handprint, if you want to call it like that, over the state policy that is either the decision to deprive a minority group of its citizenship and make it stateless, or to continue that policy if it's already been something that's been ongoing from a previous regime or government.
Thanks so much for clarifying that. If I may just push you a little bit more on the issue. So one of the questions that has come in considers that the offshore detention of immigrants by Australia was not considered by the prosecutors fulfilling the chapeau element. And do you think that it is likely that there will be cases in the future on arbitrary deprivation of nationality, and whether that specific element would be a particular hurdle in any possibility to prosecute around arbitrary deprivation of nationality?
Well, the decision, I mean, the Australian situation on the offshore detention, you had a point at which the conduct was considered to be potentially criminal in terms of the deprivation of liberty that was ongoing. But as you said in the question, it was a case of it not meeting the chapeau element of being a state or organizational policy. So, I mean, I think realistically we have these chapeau and contextual elements because we need to ensure that the conduct that reaches courts as potential crimes against humanity is worthy of reaching that value. I mean, we have to have those parameters, so to speak, in order to ensure that we have good prosecutorial decisions and we don't have potentially the chasing of particular conduct or accusations that a prosecutorial authority is going after a particular state or a particular issue on issues that are non-legal or considerations that are non-legal. So I think those contextual elements are really, really crucial in order to get us to a point where we have decided as a community to say the conduct must reach the threshold before we deem it grave enough and warranting international criminalization. So, I mean, to be honest, if it's an obstacle to prosecution, then it's an obstacle for a good reason. It's a policy element that's been decided at least at the ICC, and I should preface the fact that what we might consider to be customary international law in terms of contextual elements doesn't necessarily have that organizational or state policy element to it. That's something that the ICC has focused on. So it is possible that you could have another ad hoc tribunal if one is created, or you could have a domestic jurisdiction that applies what it considers to be customary international law, not having that element of a state or organizational policy. So I think it really depends on the forum, but like I say, if the avenue is the ICC, those are the parameters that we, when I say we, I mean those who have negotiated the treaty, and more specifically the judges who are interpreting the statute, have decided that those are the elements that need to be met. So you deal with the law as it is before you.
Thanks so much. So one of the things that you mentioned in one of your previous answers is that you also referred to children. And one of the questions that has come in as actually relates specifically to children, and asks, how would you judge the risk of children being born stateless due to current citizenship stripping measures in relation to foreign fighters terrorism? So those who are deprived of nationality for national security reasons in a counterterrorism context.
That's obviously a very topical question. I think it's one that's a little bit beyond the parameters of this lecture in terms of the potential applicability for international criminal law. That's obviously a terrible situation, a dire situation where you have kids who are born into statelessness, and all of the devastating effects, I suppose, that will likely follow them in their lives. But if it is a situation, again, like anything in international criminal law, it really depends on the facts that you have before you. If it's a situation where it is kind of piecemeal action against particular individuals that results in the statelessness of their children, then that wouldn't be at a level of gravity and seriousness that would engage the elements required for international criminalization. So you really would need to have something more again, kind of going back to the chapeau elements of being widespread or systematic. You need to have something that's more concentrated in terms of the targeting that's going on. Arguably, it might go into the question of you could look at international humanitarian law, but there you require a link to an ongoing international conflict, be it international or non-international armed conflict. Sorry. So I think those kinds of situations are, like I say, they're extraordinarily unfortunate and saddening, but the reason why I emphasized at the outset of the lecture that this wasn't an attempt to expand international criminal law is because people will, I think, naturally be a little bit skeptical of any suggestion to bring new conduct into the realm of international criminal law for potential penalization. So we need to be, I think, as international criminal lawyers, we always need to be careful that we don't push too far and undermine the credibility of what we're suggesting in terms of when we're trying to develop things. We don't want to undermine our credibility.
Yeah, totally understood. In terms of the criminalization of these acts, there also was a question that came in about alternatives to that. So is the criminalization path the right path, or is economic sanctions actually also a possibility? And what do you think about what could be the more likely or more appropriate response in relation to arbitrary deprivation of nationality?
Well, I suppose it's a good question in terms of you should always try and pursue the options or any options that might ameliorate or change a condition of grave human rights violations. So obviously economic sanctions are a way to try and put pressure on a state to amend its behavior. But I think we've also seen in the very recent past in some states where there has been situations of arbitrary deprivation of nationality, and those states have been subject to a fairly serious economic sanctions, and yet it hasn't been enough to dissuade or to change behavior on the part of those in power. Now, that's not to say that suddenly international criminal law will make people think twice. That's just to say that I think both options have their positive aspects and their potential drawbacks. But I think economic sanctions have probably shown us that they're not always particularly effective in amending state behavior sufficiently in order to really improve a human rights situation to a very large extent.
Thanks so much. So a couple of questions have also come in around individual responsibility, individual reliability, and who would basically be put on trial, so to say, because a crime of mass arbitrary deprivation of nationality would be committed via government policies and laws. So who would then be liable for the commission of such crime? Could you discuss that a little bit?
Of course, and I think I might have maybe touched upon it a little bit in an earlier answer, but given, as somebody raised, the bureaucratic nature of any governmental decision or state decision, for something like this where it is a state policy, I think you would need to look at or classify it as a leadership crime. So basically those who are in a sufficient position of power to either drive or amend state policy. So again, be it, and I'm talking about de facto positions here, not de jure positions. So not for example, a figurehead president, just because they are the president of the state and maybe the head of state. If they have no power to actually influence state policy, then you wouldn't be looking at those people for our potential criminal responsibility. It's really those who might be the intellectual authors, or who might be the driving forces behind, again, either the implementation of a policy or maintaining that policy, ensuring that there's sufficient support for it, or continuing with it, even if there are questions being raised by the outside world or by the international community, for example. So it's those where you can draw a clear link between the individuals with a sufficient power to either amend or continue, or to instigate or perpetrate these types of policies, and those who, separate those from maybe the individual who might be voting in favor of legislation because it's politically expedient to do so. I think realistically, again, a bit like the crime of aggression example, you would need to be looking at those who are at the center of the decision making.
Thank you so much for clarifying that. We only have a couple of minutes left, and I wanted to put at least this one last question to you that has come in around state discretion in nationality matters. Do you think that states have or should have more discretion in relation to the rules of acquisition of nationality than they have or should have in relation to the loss or deprivation of nationality? So does the state have a greater obligation to preserve nationality already required, basically?
Could you repeat that question? Sorry.
Yeah, absolutely. It's a bit of a long question. So do you think that states have or should have more discretion in relation to the rules for acquisition of nationality than they have or should have in relation to the loss of deprivation of nationality? So do states have a bigger obligation in preserving a nationality that's already been acquired by a person or not?
A bigger responsibility to preserve rather than deprive, I guess, is the question.
Yeah.
Well, I think, again, as outlined, and part of the difficulties raised in the question of criminalization is because it is really seen as a particular sovereign act, and it is quite a jealously guarded one in terms of the state deciding basically who's a member of its tribe, to put it in its sort of most basic fashion. So I think, I think that there's already quite a wide discretion, even going back to the Statelessness Convention that I mentioned, the Reduction of Statelessness Convention. There is the allowance for states to deprive a nationality even where it results in statelessness. provided that there are strict requirements met. So I think there's a wide discretion there as to what states can actually do in the realm of nationality. Whether there's a greater obligation where to keep nationality rather than to deprive it, I would probably look at it from the opposite perspective in terms of, you know, the consequences in either of those situations or both of those situations are, you know, very grave if it leads to statelessness. So I would think that the assessments and the considerations that go into either of those decisions have the same kind of balancing act, and I wouldn't necessarily put one as more weighty than the other.
All right, thank you so much. Unfortunately, we're running out of time and we have to wrap up our discussions on citizenship stripping for now. I don't know if you have any final remarks or words you want to share with the audience.
Just to kind of laud the ISI for making this the year of action and for taking it upon itself to organize, you know, not just the lecture series, but also, for example, the report that was produced last year. So I think that those kinds of things that highlight this really crucially important question and bring it more into people's minds and get people thinking about the different aspects of it and the effects of it and how it might be tackled. I think that's really invaluable, and I would just say to ISI to keep going with the great work.
Thank you so much. That's much appreciated on behalf of all of ISI. And thank you so much for your lecture as part of this global seminar series on citizenship stripping, because without all the speakers, we obviously couldn't pull this off. I would also like to thank all of the participants for joining and for asking some great questions. And finally, I'm very grateful to my colleagues at the Institute who've worked very hard behind the scenes to make sure that everything today ran smoothly again. So next month, on the 14th of June, there will be another chance to discuss the issue of citizenship stripping, this time from a human rights and security perspective, with Christoph Paulussen and Martin Scheinin. More information and registration is available on our dedicated website. And if you want to stay up to date on the global seminar series about the work of the Institute and the year of action against citizenship stripping, you may also want to consider signing up to our monthly bulletin, which is also available through our website. So I want to thank everyone very much again. Have a wonderful day, and hopefully until the next seminar.